We'll call to order the March 13th meeting of the Collection Service Board. Ms. Hancock, would you read the roll, please?
Before I call the roll, I'd like to read into the record the efforts we've made to give public notice to this meeting. I'll be doing this before each meeting. This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of its year's meeting calendar since September 24th of 2012. Additionally, the agenda for the meeting has been posted on the Tennessee Collection Service Board's website since March 5th, 2013, and has been noticed on the Tennessee.gov website since 2/22/13 and edited again on 3/8/13. And now I'll call the roll. Bart Howard.
Here.
Elizabeth Trinkler.
Here.
Elizabeth Dixon. Here. Steve Harb. Here. And Chip Hellman. Chairman, you have a quorum.
Ma'am? Has everybody had an opportunity to review the agenda for today? Is there a motion to adopt the agenda?
So moved.
Moved and seconded. Any discussion? If not, we're ready to vote. All in favor? Aye. Any opposed? Minutes from the last meeting. Has everybody had an opportunity to review the minutes? Changes or corrections to the minutes? If not, I'll entertain a motion to approve those minutes.
Second.
And seconded. All in favor, say aye. Aye. Any opposed? Okay. Mr. Whitaker, legal report, sir.
Thank you, Mr. Chairman. Handed out copies of the legal report, a total of 25 complaints for your consideration. Would especially like to direct the board's attention to items 1 through 5. Those are complaints that the board has considered previously and had referred for a formal hearing, and after a formal hearing was instituted by our litigation counsel, Ms. Ryan, and then counsel made an appearance on behalf of these respondents, and Ms. Ryan and myself have done quite a bit of work with opposing counsel to try and come to a proposed settlement agreement that would dispose of the allegations in the complaints without the need for a formal hearing. Ms. Ryan and I are both of the opinion that the settlement is reasonable given the circumstances, and we will certainly be happy to entertain any questions that the board may have relative to those complaints. And if at the end of the legal report part of the proceedings, if the board approves this proposed settlement agreement, then Ms. Ryan will have some paperwork for Mr. Howard to sign so that we can get these complaints disposed of and off the books. So with that, I'll turn it over to you, Mr. Chairman, and have you guys.
Okay. Is everything that you wanted us to review about these three agencies in this report, or is there anything that you want to add about them, or?
No, there are three separate entities, but none of the three of them currently or at the time of these allegations possessed a collection service license. It's Ms. Ryan and I's opinion, and based on representations made by opposing counsel, that these entities are interlinked and affiliated, although separate separate entities for, I guess, business purposes. Like, for example, they probably all have separate business licenses, but at the end of the day, the same folks are kind of pulling the strings behind the scenes. And
have they stopped?
Yes,
collections.
They have, and I would say it's probably been at least a year since anything like this has happened. And some of these complaints, if you'll note from the complaint numbers, are older. We've got a 2009 complaint number in there, a couple 2011s. And one more thing to take note of, part of the reason for the recommendation that is listed on your report is, although there are 5 complaints there, after careful analysis of the law and rules that we have to work with, Ms. Ryan and I were of the opinion that, push comes to shove, we could probably prove 2 allegations of unlicensed conduct without much difficulty. However, I think our chances are slim to none at best of potentially proving the other three allegations, simply because they didn't really have any impact on delinquent debts attempted to be collected in Tennessee. We're talking about out-of-state entities attempting to collect from out-of-state debtors for three of these. And it just, based on the law and rules we have to work with, we would have had a difficult to impossible time trying to prove those. So if we can, if we can get these complaints disposed of, assess some discipline for it, and as part of that settlement, get the main entity who really, who we were really concerned about in the door and under the umbrella of the board to apply for a license and become licensed in the event that they'd like to do business here. And they've said, we're not for sure that we will, but, we would like to err on the side of caution and, work with the board. And if we're going to do it the right way. So as part of that settlement, they'll be required to submit an application within 180 days. That doesn't say what the board must do with it. It just says that they have to submit it.
You do have to submit an application.
That's part of it, and it's set forth in the proposed order that you'd be seeing if this.
Okay, we're going to go ahead and read the entire report and then come back to that, or do you want us to vote on that specifically?
You just do it the way you usually do it. Just go through the report, make notes of any questions or topics you'd like to discuss for each matter, and then we'll take them one by one and do any amendments necessary.
Everybody finished? Any questions? Number 15, it indicates that the passive debt buyer reported the debt on the debtor's credit bureau file. They say here that they're going to remove it and so forth. What's their policy going in the future? Are they going to continue with those debts?
Spoken with the, I guess it's the equivalent it was, but in order to try to minimize, if not eliminate, things being reported on a credit report that shouldn't. I think the time period that was quoted to me was 30 days. So, during that time period, if they get notice from the debtor that it's fraud or identity theft or something like that, then it would never go on the report in the first place. I just think this one didn't fall within that exact time period because I think that. But I think that's a fair compromise for the agency to do, because that way it sort of, well, it's not an agency, but for the passive debt buyer to do, I should say, because that way it's not just, it comes in the door and it's automatically reported and it never should have been in the first place, and there was no opportunity to even really look at it and see if that was the case or not.
This doesn't completely tell us what happens, but typically a debtor, when he recognizes this on his file, he's going to pick up the phone and he's going to call the company that's reporting that, and I wonder how that company responds to that debtor at that time. Or does it immediately go to a collection agency and they not attempt to collect it, or?
Very clear. Yes, did the agency report it or did the debt buyer report it?
I want to say that the debt buyer reported it, but if you look in the paragraph to answer Mr. Howard's question, is that if there's going to be any collection activity, there's supposed to be, the account's supposed to be referred to a licensed collection agency, and when they make contact with the debtor, then the debtor would in turn call that person. But I understand your question about if the passive debt buyer credit reports the item, then that is a perfectly natural, reasonable reaction for say, okay, well, ABC Corp credit reported this. Let me call them and see what's up, because I don't know what this is. I don't know if with those calls they refer them to an agency. I could certainly find out if you would prefer that, and table this particular item until the May meeting.
No. Yeah, no, I don't think just by placing it on the file is an attempt to collect a debt. But I'm wondering how the debtor, how the relationship between the debtor and this passive debt buyer goes if the debtor calls the passive debt buyer and says, "What about this account?" I don't know that I know the answer. How it should be.
No, if there was direct contact made, and this is just off the top of my head, but it would seem like at least a logical response would be, okay, this is a delinquent debt that is currently being collected by so-and-so agency. Here is their phone number. Please contact them. That would.
What we would hope, yeah.
Right.
That's what you hope would be the answer, but because I don't have that information as of the drafting of this report, as I said, I'm happy to table this one until May and get that information and bring it back to you if you'd like.
I think it'd be interesting for our future knowledge as well, because this is a practice that's going on. We're going to see this again, so I think that's kind of the important issue here. Right here, then.
Glad to.
Other questions?
Make a motion, accept the legal report?
Motion's been made
Second.
and seconded that we accept the legal report. Is there any discussion? All in favor?
Aye.
Okay. Thank you, Mr. Whitaker.
I could put final order for me, like,
Certainly will. Yes, ma'am. Administrative report, Ms. Hancock.
Yes, Mr. Chairman, if you'll turn to tab 2, the first item under my report will be the complaint comparison reports from this March to last March.
How did we get to the tab 2 from here?
Do you not, is it not listed as tab 2? Back to the library.
See it on his.
See what Chris.
No, that's
or
what I'm
Chip's.
looking, but it's not on here.
Let me see what
See real
Chip's
quick,
got.
there we go.
Here we go.
We got it.
Thank you.
Never mind.
Just trying to hold out on me here. Okay.
Tab 2?
Yes.
Okay, the bottom block, even though it says Mary 11, 2013, that should say March 11, 2013.
It's a combination of the months of March.
March and May is
And the Merry March of May. There were 43 pending complaints versus 82 last year. This year, 11 of those, for 25.58%, are over the 180-day benchmark, from which we like to find a resolution to those complaints. Last year, there was 59 of those were over 180 days. So,
Excellent.
are making progress. Tab 3 is your budget report for this month. The top page there is your revenue. By the way, they are still, have construction going on in this building. The floor's above us, so you'll hear the jackhammer occasionally. And if you can't hear me for it, just tell me to hold on a minute. The right-hand column is the year-to-date totals that we have so far. We've got reports through January 31st of 2013 showing that, and again, we're looking at the right-hand column. Those other columns are just for comparisons of the final closeouts for fiscal year 9 and 10, 10 and 11, and 11 and 12. But the right-hand column in the yellow there shows you the total revenue we've received so far from monies to the location manager fees, $38,840. The bottom block shows that the collection agencies, so far, we've received $217,665 in fees from agencies, and that shows you where the fees are coming from: application license fees, solicitor cards, renewal solicitor cards, renewal of the license fees, miscellaneous, and so forth, for a grand total of revenue received as of 1/31/13, $256,505. The next page over is the expenditure report. In the right-hand column again, that's up to date through 1/31/13. The other columns are finals for those 3 fiscal years. So far showing that a grand total of expenditures of $122,027. And again, revenue as reported from administration is $250,592. Always going to be a few $1,000s difference between what administration reports to us in revenue, what we report ourselves coming out of the computer system of the receipts that we see in-house. But at the end of the year, it'll all match up. Any questions on that?
Shows the regular salaries of $63,423. Is that the whole year?
No, that's just through 1/31.
Okay, so that's just 1 month.
That's from July, when the fiscal year began. It's 7 months.
Right, thank you.
What about fines?
I'm sorry?
Fines that we,
Civil penalties are
Civil penalties.
reported in the miscellaneous, in the revenue.
okay.
They'll show up under
Miscellaneous
miscellaneous.
late fees? Okay.
Yes. Any other questions on the tab 4?
3.
Okay, on tab 3. Then tab 4 is just some information on your location manager exams that have been given with this new provider since September. So far, there have been 141 applicants take that exam. 68 were first-time passes, 48 were first-time fails, 23 were repeat passes, and 2 were repeat fails. Just as an aside note, as of March the 5th, we had 212 location manager applications pending taking this exam. And Judy and I have figured that 3/4 of those pending applicants are people who were awaiting for us to get a new exam. So they've been sitting there waiting since September when the exam became available, and they've not made any effort to.
Write them a letter and let them know where they could take the test and all.
I don't know why maybe they found other employment, they decided they didn't want to do this. Nevertheless, next is item 5, and I have a handout on this. We have not had a board meeting since this Senate Bill 0148 was introduced in the legislature. Judy, will you? I've given you here a copy of, and we didn't get this onto your notebooks, but Judy's bringing you copies of the bill itself. There's an amendment to the bill. I've copied that for you also. And then I've given you a copy of the tracking, where the bill is currently. Senate Bill 0148 is it's a broad bill, and it changes, it amends 2 or 3, maybe 4 of the statutory language in other boards, not just the Collection Service Board. But I have highlighted the sections of your laws that this bill will change. And you'll see under Section 6, TCA 622108 is amended by deleting the section in its entirety and replacing it with language that says the board shall be promptly notified in writing of any change in address, management, or ownership of a collection service business. Also deletes 622125, and it deletes 622126. And this is all language pertaining to the location manager. This bill deletes the requirement in your law to have a location manager license. So, as I said, there's an amendment to the bill, but I don't think it amends anything on the original bill other than it renumbers. Once it deletes that section of the law, it renumbers that subdivision accordingly. And you'll see it brought in some other language from the statute pertaining to location, leaving that all out, the whole program out of your laws.
So it's deleting the location manager, not the collection agency licensing?
No, just the location manager.
Just location manager.
Background on it.
Well, as you know, we had trouble finding an exam. took us a year to get that exam in place, and they only agreed to offer the exam for this 1 year. When we had that problem finding an exam, we did some research and we found that we are one of 2-3 states that even offer an exam out of just a handful of states that even have a location manager's license. So it was discussed. We talked about it in a board meeting, and I believe it was Chairman Howard that brought the question out as, why do we even have this license? Or do we even need the location manager's license? So it was at that time, I think, it was discussed with the commissioner. The commissioner decided to put it in her package, and this is where this bill is from, sponsored by Senator Norris, and it is going right through the legislature. On March the 6th, it was in a subcommittee I had to go up there on, but it passed out of that subcommittee with the amendment on it, and today it's up in the Finance, Ways, and Means subcommittee. So,
I think we still need a manager. My point was that the testing it's been so difficult to find somebody to do testing. Other states don't require testing, but I still think it's important that somebody be responsible at that collection agency for complaint resolution. Who do we talk to, and so on. So,
right now,
Sort of a
that's not-
contact person as in the agency.
If I could speak to that, I think that actually might be something that could be addressed within the confines of the remaining statutory scheme, assuming that this goes through this bill, which it probably will, because stuff that's part of the governor's package, when you have this kind of majorities in the legislature is probably going through. But if the board's interest is to have a person who is a specific point of contact for complaints, all that would require is, adding a line item to the application forms and or the renewal forms. And that would not only give new applicants the opportunity to designate someone that they wish for us to contact who would be, and I think that would be a great thing, because frankly it would make my job easier, because then I don't have to call and, go through this is an attempt to collect a debt. I'm like, yeah, I'm not the debtor, thank you though. I would have somebody to talk to that's designated, and then on the renewal forms, that would give agencies who wish to change their designated person an opportunity to do so. I mean, it's a very small amendment, and it's to our existing forms, and it's permissible under current statutes, because the applications, typically the language says shall be submitted on a form prescribed by the board. And if the board wishes to have that information as part of the initial and or renewal applications, then I think that's perfectly reasonable.
Since I've been with this program, December '07, I've never seen a complaint against a location manager. Disciplinary action. Most agencies, I would say at least half of them, are managed by firms who take care of the renewal process, they take in the complaint, they assign an attorney. We really never have much contact with a location manager after that license is issued.
I can think of, since I've been board counsel, I can think of exactly 2 phone calls that I've ever made to attempt to contact location managers, and those were only for agencies that appeared to be out of business, and we were hoping to obtain some information about that to see if somebody somewhere could tell us if they were in fact still doing business or not. But other than that, especially with the agencies that I see most frequently, some of these places have entire compliance departments or designated people or something like that. But the change that I recommended on the initial and renewal forms, I think could go a long way in making sure that we have the information we need to get to the folks we talk to.
size and all.
Lawyers.
Plus, license renewal. Hard to respond.
Well, on the registered agent end of things, that is just as often as not someone who is designated by the agency to receive mail or otherwise be contacted, especially when you have an out-of-state agency, but who wants to have somebody who's a point of contact within the state of Tennessee. And sometimes, in fact, it absolutely is appropriate to contact the registered agent. However, if it's a substantive matter such as a complaint or an issue with the license, unless that registered agent company is actually in charge of that stuff, then that's not the folks we need to talk to.
They will pass.
Well, sure they will.
That's really what a register. They
Sure.
make sure they're notified. You really want to make sure they'll hear about it.
Absolutely.
I don't, you know, we've talked a lot about agents that, companies that are applying for a license that are in India or China or what have you, and we've had this difficulty with their credit report and what have you. And the only thing that I see, and it may not even be an issue, is the moral turpitude of that agency. The only way we can get to that agency is through the manager. His credit report and his background and his criminal histories and so forth. So I imagine that somebody could open an agency without a manager, with having no manager at all, and run it out of their basement, and they're here today and they're gone tomorrow, and they've taken the client's money and what have you, and we don't really have a person that we can go after or ended that issue before it happens by having a manager.
Concern, Mr. Chairman, is well taken. I guess what I would bring to the table on that point is, let's say, best case scenario, we have a location manager to contact, and they're working for, a shady agency that's going to go steal people's money. Location manager is, at best, an employee of that agency. Maybe they're a partner, an owner, or something. Maybe they're not. Maybe sometimes on the smaller folks or smaller companies they could be, but I'm not exactly sure how much more rooted in the ground it is, other than just to be able to contact that person and maybe talk to them, as opposed to somebody at the company.
Person who actually renewal application requires the owner, a signature of the person in charge, an officer, an owner. That person is more likely to be the contact person and someone who would respond because they've signed an oath on the application. The licensed location manager, I've never, often it's the same person who signed the license. It would seem like that would be the one we'd want.
And that's an excellent point. What I would say about the owners, sometimes they're owners in interest only, meaning, yes, they have a financial stake in the company, and they might own it, but they don't run it day to day. They don't.
Got a complaint?
No, I absolutely agree, and I agree on that point as well. I was just putting out for the record that sometimes they're not as involved. Some owners were more involved than others. That's all.
And any lobbying on the part all rolling?
None that I'm aware of.
This is really motivated on.
Yeah, I think they, as far as I know, they discussed this issue a few months ago, I think after our board meeting where it was discussed. And as far as I could tell, they
You remember, members
Audit.
of the association were in the back of the room that day. We were talking about the exam, and one gentleman stood up and made a comment about either didn't need the exam or we didn't need the license, one or the other. So
I don't think they could really reach a consensus. I think there are opinions, but I don't think that they can agree. And so I think they decided. What about the revenue derived from the
the fiscal note shows that it would be sort of a wash. It would be like a $40,000 decrease in, but also increase in expense. So there's a lot of staff effort, a lot of your time, a lot of Judy's time and my time and Chris's time going through. I'd say there's more effort goes into reviewing these location manager applications than there are in agency applications. Because of the the credit report, Judy looks at them. If it's not all there, she sends letter after letter getting everything she needs. Then she brings it to me, and I review it. And if it has some issues or derogatories on the credit report, share them with Chris. Chris looks at them. Then we bring them to you, and your agenda, that's what usually takes up most of your agenda. So I think staff efforts could, if that goes away, could be moved into another program, decreasing your personnel. Difference in your.
As long as the protection, as long as the consumer protection is protected, then I'm all for the less licensing, the better. I like it. I like it. The less government, the better. I like it. But when we had a manager, assuming we lose it, when we had a manager, we had that 2 years of experience requirement that goes away. So anybody with a bond can open a collection agency, and the idea that anybody could do it is what bothers me.
Well, usually those those smaller agencies, those fly-by-night agencies, the company license is held by the same person that holds a location manager license. They're a small operation. He holds both, and so discipline the agency.
There's still language in the for receiving a license concerning the owner's financial responsibility
Yes.
and
None of that
their
changed.
their record, as far as even criminal record,
Financial report,
financial
bond.
reporting, and all of that stuff. So,
Okay.
And that's an excellent
and I
point.
think that's something that probably we do need to be even more careful about, being sure that we do review those carefully now, since we don't have this other, that we really look at who are the owners, who are the managers going to be, and if we have any question about whether or not they're capable or have the experience, raise that issue for the license, overall.
And I think, to go to your point, that's where 6220-107, qualifications of applicant, that's where the trustworthiness, financial responsibility, those, whatever efforts may no longer be expended on the location manager part of things, if it comes through, to the extent that any of that is redirected within this program, I would say that it needs to go there to make sure the folks on the front end that are coming in the door are financially responsible, are trustworthy, and all those things. And this is one of the broader statutes giving the board a lot of latitude in deciding who meets this and who doesn't. So that may be something that you will see more of, maybe as the location manager part of your binders goes away. There may be more questions about agency applications. So just kind of be on the lookout for that.
Or maybe even some
Okay.
questions about management, and I think you could even ask about experience of management in the application. Why you couldn't.
at a point of I have such a problem with our
We can have that as other discussion if you want to.
Appreciate
That's been a question at this board for many years.
When would this go into effect if it does?
As soon as it's passed, I think,
Typically, there will either be effective immediately on the governor's signature or on a date certain. A lot of statutes you'll see July 1 or something like that, but it depends on when it's signed. So,
People aren't going to ask for a refund if they've just paid for their location manager's license, are they?
well, Chris and I talked about that, and
tough.
Turn it over to the agency for claims.
No.
it was exactly.
Place it with an agency like that.
the position that if that inquiry came up, which obviously we hope it doesn't, but if it did, I think there's a perfectly reasonable answer. At the time that you paid the fee and, applied for your location manager license, that was the legal requirement in effect. You understood that, and the board and board staff rendered the services that part of that fee goes to defray to make sure that those legal requirements were met. And so, the fact that the legislature came along slightly after the fact and, removed that requirement is irrelevant to that particular transaction.
I won't write that.
If I write it, it'll be much nicer.
No, I just thought I'd ask since I had a feeling it might come up. Thank you.
Thank you. Any more discussion on Senate Bill 0148? All right. We'll move on to, is it tab 5 now?
Tab 5 is a question regarding a mortgage servicer. And just for the record, I'm going to read part of this letter into the record, starting with the second paragraph. He says, our client is a mortgage servicer who has a mortgage licensee and a mortgage broker, lender, or servicer bond in Tennessee. Our client engages in ordinary servicing of residential mortgage loans, some of which may be delinquent. Our client's communication to the borrowers is limited to interstate communications, telephone, fax, and mail. However, sometimes our client will hire an agent which is itself licensed as a collection service to knock on the doors of borrowers. He quotes Tennessee Code Annotated 6220-1023 and goes on to say, our question is, does the state consider a mortgage servicer who is licensed and bonded in Tennessee as a mortgage lender to be engaged in the collection of delinquent accounts? If a portion of the serviced loans are delinquent, we would suggest that our client's mortgage license and bonds sufficiently protect the interests of the people of Tennessee. Furthermore, if our client solicited mortgage servicing business, which again may include both current and some delinquent mortgages, from creditors located in Tennessee, would it then be considered a collection service under Tennessee Code Annotated 6221?
Like that if the contacted person or company that other than the original lender, then they are a collection agency. Conversation, I'm sure.
Oh, I'm confused about, I agree with our chairman. Just, it appears that there's something going on here because it says that mortgage servicers do have to be licensed and bonded, so there's another licensing procedure for these entities.
Mortgage brokers?
Mostly to do with their financial, doesn't really collection tactics or
Licensed under financial institutions? Is that who regulates them?
I'm not at all sure that, the mere fact that they are soliciting mortgage servicing business puts them under the statute. I mean, that's, you're trying to go get business.
Are they attempting right, and are they actually saying you need to pay your bill, or are they saying why don't you
Sell you a new mortgage?
sell you a new mortgage and wrap your existing bill? So
Well, the letter itself says that our client is a mortgage servicer, which indicates to me that, at least by the plain language, they're probably not the same party that originated the loan. If it's, if you get a loan from XYZ Bank, unless XYZ Bank is servicing that loan, then you're dealing with a servicer. Right.
we're just play.
Yeah.
Most mortgage servicers receive the loan upon upon that loan being made. From what this says, they may buy these loans after they've become delinquent. They may service them after they service a delinquent loan licensed.
Point of fact, Mr. Chairman, that this board has issued quite a few licenses to mortgage lending and servicing folks, and some local, some nationwide, and the folks who have obtained those licenses, at least as I have read their sentiment, is we'd rather be safe than sorry. I mean, we may deal with a dozen delinquent Tennessee loans in a year, but that's important to our client, or it's part of our portfolio and we got to do it. So
Well, then we need to be consistent.
Your point, Chris, it's not necessarily us or the fact of what we can do with a cease and desist. It's what somebody in some other lawyer in some other town that's going to sue this company because they were collecting without a license. That's what they should be worried about. In the past, I think you've written letters that say that here's the statute. You determine. Required to tell them yes, you need a license, or no, you don't.
Well, I'd say that in any given situation like this, the board has three options. You tell them, no, you don't need a license, and and maybe provide a reason, maybe don't. Yes, you do need a license, and here's why. Or that third option, which you just mentioned, is here's the statute, you make the call, and we just have to take it on a case-by-case basis. And if any complaints come up, and during the investigation of those complaints, it looked like you were engaging in conduct that required a collection service license, then you may be rung up for unlicensed conduct. And if you want to take that risk, then that's up to you. So
This is a law firm asking the question.
I'm aware of that.
For their client.
Well, and you could certainly say that we have what we believe to be, from what they've told us, similar entities that have chosen to license.
Sure.
So you can give them that direction without.
The board is also within its rights to make a recommendation, but not a requirement, if you so choose, that, based on passport board precedent and, our review of active licensees, which appears to include similarly situated companies to your client who have become licensed, the board might respectfully recommend, but not require that you become licensed.
Kind of like that option.
I'll make a motion we do
really
that.
good.
Motion what you just said, right?
I'll make a motion for what he just said.
You'll write that down for me.
Sure, why not?
Button by mistake.
No.
Okay, there you go.
Should we?
Well, it may be this licensed manager issue that prevents people. We may find that we have a lot more collection agencies licensed because we don't have that
Requirement.
requirement of taking the test first and then becoming a manager.
Notwithstanding that, if they're of service and they're
I think so. If is there any more discussion, I think maybe I like Chris's last, we suggest that you get a license and other, what Chris said.
Writing that down, and it will be a motion. Someone
moved.
made a motion,
I
Elizabeth?
made the motion.
second.
Motion's made and seconded to accept legal counsel's verbiage of a letter to go to this law firm that outlines what our board has decided in the past, and recommending that they do get a license. All in favor? Aye. All opposed? None.
Tab 6 is also going to require a discussion regarding a call center. I'm going to read part of this letter into the record from the Chug firm. Sobey Matthews wrote this letter. He says, and I'm starting with the paragraph under proposed activities. IBM DAX, and that's the only way I know how to pronounce that, DAKSH, operates a call center outside of the United States, and they handle both inbound and outbound calls from this call center, with a large number of the calls being received from and made to the United States. The services of IBM DAX are being retained by a creditor who has debtors in the state of Tennessee. However, the corporate headquarters of the creditor are outside of the state of Tennessee, and all documents/information that is provided to IBM DAX is done outside of the state of Tennessee. At no time are instructions given to IBM DAX from the state of Tennessee. Furthermore, IBM DAX does not have an office or any employees in the state of Tennessee. The scope of the services provided by IBM DAX is as follows. IBM DAX will call the debtor located in the state of Tennessee and will identify themselves as calling on behalf of the creditor and will seek to follow up on the outstanding debt. At no time will our client identify itself as the party entitled to the debt, and all collection/payments made pursuant to this effort shall be directly to the creditor. All contact with the debtors will be made in the name of the creditor. At no time will IBM DAX receive any payment for or on behalf of the creditor. And the control and direction by the creditor. Additionally, the activities of IBM DAX will be highly regulated by the creditor, and all activities of the agents at the call center will be largely monitored by the creditor, who will exercise control and direction over the employees. Number 1, the calls will be made by IBM DAX in the name of the creditor, and the agents will identify themselves as calling on behalf of the creditor. Number 2, the manner in which the calls are to be handled, the script for the calls made, and the overall process which is followed by the client will be dictated by the creditor. Number 3, the list of the consumers to be contacted will be provided on a regular basis by the creditor, and there is no discretion with the call center as to whom the calls are to be placed. Number 4, the data will be assessed by the agents on the creditor's system, and all updates of the calls, I'm reading this as it is, by the way, will happen on the creditor's system. And number 5, all payments made will be directed to the creditor. They feel like that based on the above fact, it's the understanding that our clients are exempt from obtaining a debt collection license under TCA 622103.
It's early.
I think it's early out.
It's extended business office, yeah. I don't think they need a license.
Say that again.
It's extended business office. They're just operating in the name of the creditor. They're not using a third-party name. They're not accepting any payments, like they said.
I don't think that they need a license. Is there a motion?
So moved.
Motion's moved and seconded that this IBM DAX does not need a collection license. All in favor? Aye.
I had a follow-up question from this company. Oh, here it is. I'd written them and said that I would bring their letter to them at today's meeting. And they all wrote back and said, We have another question. As we understand, the exemption, if granted, is only for debt collection concerning consumers. Does Tennessee require a debt collection license for business-to-business collection? And we get this question a lot. Does this board regulate commercial collections? I've always understood that there's no
No distinction
yes.
between.
Collecting is collecting. Debt collecting is debt collecting. I know Chris says the FDCPA doesn't require.
Federal laws has distinctions on that, but the statute, the Collection Service Act, merely talks about collection of delinquent accounts, bills, or other forms of indebtedness, and doesn't really make any kind of distinction between personal and consumer debts. Just for the board's information, the complaints we typically get on the commercial accounts typically cite the FDCPA, attempting to force the requirements of the FDCPA onto commercial collection efforts, and that's just not going to work. And that's why most of those cases are recommended for dismissal, not because there may not be something wrong with the tactics if it were a consumer debt, but because it's not, you can't apply a statute that only applies to one kind of debt to something that is not covered.
I think the only thing that this board would have authority over, if that's what it is, would be the license. Anything that they say to that commercial debtor is not covered.
All of the regulations concerning fiduciary responsibility,
Yeah.
all that still is very much in
Bond
play,
and
the
all
bond, all of that, and it's still very much a protection in my mind to that consumer who is a business, that they protect that relationship financially. So I think it's important.
They're
Are exempt?
From a license?
Commercial.
oh no.
No, they're not exempt.
Collecting from business.
All in their own.
Yeah, the statute doesn't distinguish between consumer and commercial collections, and our statute doesn't distinguish between consumer and commercial collections like the FD. Therefore, they are required to have a license.
I just want to make sure that there's not any confusion when a letter gets sent to these folks, because the letter says, okay, we're setting forth this list of business practices, and based on this, do we need a license or not? The answer to that was no. But then they sent that follow-up question, and so just to be clear, you make sure that if you're asking, do you do commercial debts in the same way as you did what's in the letter, consumer and commercial, then the answer is still no. But if you're doing something different for commercial debts that's not covered in your letter, then the answer might be different.
That's correct.
So I just didn't want to kind of create any confusion where we say, yeah, no, you're exempt, but yes, you need a license, because then at the May meeting they'll be like, what?
Well, I forgot that the second part of the thing was about the same people. So, yeah, it's the same answer for the first part is the same answer. If they're collecting in the name of the creditor,
right,
then no, they don't need a license. But if on their commercial end of it they call in the name of an agency, then yes, they do.
I'll write them a letter, have Chris review it before I send it, and then I'll also invite them to watch this discussion on.
Okay.
Last item on my, under my report is under tab 7. This is about the third time now we have discussed this little draft of tips and pointers and information I wanted to post on the website that I put together. At the last meeting, if you'll remember, Mr. Bond wanted a draft of that to show the association, which apparently he did pass along to Mr. Michael Rainwater, which is the top letter or email there, you've got in your packets, it is an email from Mr. Rainwater saying, as president of the Tennessee Collectors Association, I was asked to review the attached information and make suggestions/recommendations. I apologize for the delay in getting back to you. First, I applaud the board for wanting to get correct and accurate information to consumers. There is so much misinformation available. We strive as a state and national association to communicate correct information whenever and however possible. But also like to thank the board for reaching out to TCA for feedback. Our goals are ultimately the same, get the consumer accurate information. As for the familiar with the website, he says, are you familiar with the website? AskDrDebt.com. There's valuable information on that website. And he says to avoid the hassle of posting information and keeping it updated, I would recommend the board provide a link to this site. So I'm going to ask Mr. Bond. I don't know if we can link to that site or not, but what's the overall consensus of posting that draft to the website?
I think, well, I can't speak beyond.
Thought that our original intent in providing just makes me uncomfortable to go any further. And I'm the consumer. We don't control the response or anything. I wouldn't want to say that we endorse the sponsor of that. It worries me. I like the fact that he's being proactive. I really think that he ought to be commended for that. But it worries me that we're going one step again.
Consumer, and I've wondered if questions for now we're giving them scope, the actual process, and not consumer advocates, but certainly protect the consumer based on our way. It's a step too far of what I thought a board would do or regulatory body would do. I think it goes. I've been uncomfortable with.
Barb, if I understand you correctly, and this is just a hypothetical example, but would it be your position that these kinds of tips, things to know, however you phrase it, would be more appropriately posted, for example, on the Tennessee Consumer Affairs website?
Yeah, that's who would. ACA has. Those are the places. We take complaints. I have a little problem with that. It happens, you sure to make a, think that boards and other suggests to people how they ought to comply. Step two. Just how they can make. I don't know.
I don't think that I do think that we're all right where we are, and I applaud the fact that we did put our toe in that water enough to just give enough information for them to go somewhere else for. I would hate to see us can this as far as we do have a problem.
Going to speak. You need to come up to the microphone.
I thought I was very
No.
loud, and that everybody could hear me. Is that better?
With the red light on, we can hear
Red
you.
light
It's
is
audible.
blinking its heart out. Okay, so I actually agree with both of you with board. I think that there comes a point where, congratulations. I think there comes a point where where it can be taken a step too far, and the board steps. I also think it is a wide resource. I think that that's probably better. Providing a link. That are just existing inaccurate copies of the law, as opposed to distilling from existing law which ones are most important, which ones you should pay attention to, our interpretation of what these laws mean. And I think that those tips probably get closer to a distillation of the law and what we think is important, where we think the priorities are, as opposed to just a sort of a repetition or easier access to what the law is, and to allow the consumer to figure out for themselves which one may have been violated and make a decision as to whether or not to file a complaint. I agree with Board Member Harbin that I think what's being proposed here might be a step too far in the direction of providing consumers assistance as to how to interpret those laws, because it is not it's not just a repeat of, the language. It doesn't borrow directly from the text of the FDCPA. It is an interpretation of the FDCPA, and how consumers should view their rights in terms of what those things say. And I think that goes a step beyond providing a service, and possibly gets more toward, providing some level of advocacy and saying, if this happens, your rights have been violated, and that's a determination that normally a lawyer or an advocacy group.
I feel that what we have in front of us now is more of a cautionary.
And I would agree. I think that we would be in total agreement if the list weren't sort of picking and choosing among provisions which one to put on there. It's not an exhaustive list of the provisions of the FDCPA. It's certain provisions. Unless I don't think that a website already provide a link to that resource provided by the FTC.
And sometimes is it our role as a advocate? Maybe distilled it a little too far. You're far more eloquent than I am about how I'm trying to say it, and I appreciate it. That's my concern. It's not bad words, and what we've said is good stuff.
I didn't misinterpret what you said.
Yeah.
At all. I hear you.
But
Well, the Fair Debt Collection Practices Act uses the term least sophisticated debtor or least sophisticated person. Lots of times, I think something like "don't ignore a collector." So many times a debtor gets a letter or a telephone call and they bury their head and they think this is going to go away if I don't answer it, or if I don't take that phone call, it's going to go away. And our advice to them is don't ignore it. And I think that brings on a little bit more of our responsibility to the consumer. Just regulate the consumer, like the agencies, like them as well. I don't think that what we put in this draft proposal is any way encouraging them to file complaints. I think it's information well given to a consumer that may be having a problem with a collection agency. I haven't read AskDebtDoctor.com. I don't know what they say about that, and maybe we should table this until we've all had an opportunity. We on the need Dr. Debt.
Be able to say
Yeah.
before we do it.
It's a tongue twister. You
Yeah.
shouldn't do it because it's a tongue twister.
And if ACA is putting it out, it is not a commercial endeavor. They're not a commercial company. It says in the letter that they don't advertise it, and it may be that refer them to AskDoctorDebt.com may be kind of taking us out of the loop a little bit. I don't know.
Well, there are a couple of places, I hadn't read this draft in a while, and where we are kind of inviting a complaint a little bit. So I would offer that maybe we wouldn't take much to reword, just take that part out. You can offer information without saying, and this is how you would file a complaint. And we do that, it looks like in two different areas there.
look at the one about spoofed.
Yeah, the spoofing says,
The least sophisticated.
I can see that being a
Appeals to
problem.
them, and you say you're spoofed. Well, they call me asking me for something I don't know. I'm spoofed. This says I
Yeah,
want to call them.
I think that one's dangerous.
Language like beware. I think that's sort of an invitation to say, if you fall into this category of person, reach out to us. We might be able to help you.
But fundamentally, we're the board's on earlier. A board in the sense
Well, Mr. Harb, I am encouraged to work with and put information out there to help the consumer in the way of brochures, in the way of information on the website. Other boards do it, like the Contractors Board, they have spots on TV, what to do before you hire a contractor to come into your house, what to look for. So we are encouraged to do things like that for the consumer, offer these tips. This is the third time I've brought it to you. Chances to revise it, chances to throw out whatever you don't want in there. Throw the whole thing out if you want to. But we either don't want to put it out there on the website, or we do with some limited language. So, prior to bringing it in here.
Well, and it was initially intended, wasn't it, Donna, to sort of be of help to you too, sort of frequently ask questions to keep you guys from answering these same inquiries personally, that this might help you avoid some of
We constantly
those.
refer people to the FDCPA website or FTC website and have to give them the whole address, and you click on this at the top and click on that at the bottom to get into debt collection consumer tips, and it's just, so it was better just to draft some little things and put out there, and it certainly wasn't meant to encourage complaints, but it was meant to give the consumer more of their rights from their perspective.
Earlier,
Well, but I'm limited too as to what the state will allow me to link to. I'm not sure they would allow us to link to AskDrDeck.com.
no, I'm saying in that. But linking to what you would tell them that on there. Supposed to advice.
Motion.
Not use it. To be or not to be? That is the question.
Post it or trash it?
Move that we post as presented.
Motion's been made that we post the verbiage as written on the website. Is there a second?
Oh, well, I can't. Second.
Motion can die for a lack of a second. So if nobody seconds, then the motion does not carry.
Motion does not carry for lack of a second.
I'll make a mother. Move that we revisit the language. Umpteenth as is presented today.
Motion's been made that we revisit the verbiage in the recommended posting and come back on May 15th for a final decision. Is that correct in your
That's
motion?
correct. Mhm.
Is there a second? Motion fails for lack of a second.
Well, then, functionally, what that means is these don't get posted
Dead in the
because
water.
they weren't approved.
Oh, Mr. Chairman, that,
Christmas list.
Are you done yet?
I'd be willing
Stick
to
a
look
fork
at it
in
at
me.
another time. I'm not going to be
it
here
could-
in May, so.
Oh, it can certainly come up again, and I believe that
Yeah, I'm not
something that's-
opposed to the concept.
Yeah, the
I'm really not.
concept is a good idea, that the consumer, God bless his soul, when he's least sophisticated, you can't refer him to the Fair Debt Collection Practices Act, because that doesn't tell him a thing as a least sophisticated consumer. And I think that some of the things, a lot of what is written here is important for a consumer to know.
I'd rather you err on the side of helping the consumer rather than err on the side of helping the collection agencies.
Question,
You are to protect the public. You're not to protect collection agencies. How are they disadvantaging businesses by putting information out there for the consumer?
Well, I think it depends That's as much as.
You had a chance to change it.
I don't.
Y'all had a chance to
don't
change
wanna
it. The
revive the debate.
association had a chance to change
Oh, no, I'm
it.
happy. I'm happy with the result. I'm very happy.
Well, then what's...
No, I'm happy with the result. The result works just fine.
Hey, it's a mood issue. It's done. It's over with. Are we on break?
Touch at the top. Doesn't like
It's
it.
anywhere on.
Are we in session? Or
Yes, ma'am.
We
I'm
are?
sorry. Yes, we're through with tab 7. We're on to tab 8. I had
Okay,
lost my
I thought
tabs
y'all
up
were
here.
going to take a short break, but tab 8 begins the location manager application review.
Yes, ma'am. We'll take a short 10-minute break and reconvene here in 10 minutes.
Do we need to,
I'm wondering about that.
why do we need to review the location manager applications?
We can't bill them.
But we could hold it. Cross your legs. Whatever you have to do. Judy left, and I thought, you turned it back on.
You didn't make a move.
All right.
Okay, we'll call the meeting back to order, and we had discussed the applications for collection agency manager.
Yes. Tab 8
Mhm.
is a new applicant who answered yes to the
Make a
question.
motion.
Well, we want to make a motion.
Yes, make a motion.
I move that we table this discussion until the next meeting.
Motion's been made that we table number 8 or all of the location manager license application reviews.
8, 9, 10, 11, 12, 13.
Motion's been made that we table 8, 9, 10, 11, 12, and 13 of the location manager review. Is there a second?
So moved.
And seconded, all in favor? Aye. Any opposed? Okay, motion carries.
1 point. Pass or become.
Up in May.
Don't you feel like a big loser today, Donna? The biggest loser.
Biggest.
We're just trying to lighten your load. Look at the glass half
Wait, we
full.
have to have a dismissal.
Yeah, I think, are there any new business or new discussion?
Oh, that's right, there is one.
But I did want to talk about the agenda, what it takes form, redesign the form, the agency license form, to propose a redesign of that form, and what does it take to do that? I understand that form is kind of regulatory-wise or something. I would like at the process to redesign with questions like, who's your designated manager?
I know when I ran an agency, I had to beg my accountant to sign that financial statement, and because it is.
Well, I will bring the application in for review during your next meeting. Bless you.
Thank you.
Is there any other business, new or unfinished? If not, we'll stand adjourned.